for this hearing. It shouldn't be. Now, I have taken notes, here they are, of the 7 or 8 hearings there have been so far, and until today, because as a result of the fracas yesterday, the judge said the skirmish which has taken place on my order must not be repeated. He will not be, this man will not be allowed to return to this court or any other on this hearing without an apology, and I'm undertaking not to repeat the disturbance. Now, my observations and my notes record that throughout this hearing, the judge has repeatedly been in breach, has misconducted himself, so he's in breach of conduct.
He's not applying due process, I think the term is called.
Well,
he's not abiding by due process.
Due process may be the term, but due process is the way the law works. But I would say he is acting ultra vires beyond his powers, and I am in the process of trying to lodge an application for an injunction to restrain him from proceeding with this hearing, to answer charges of, as I say, abuse of process. Now, if that happens, and there's no certainty it will, I'm trying to do it for tomorrow morning, and it's successful, it will cause the adjournment of the hearing, which will, if it's successful again, prevent him from what he's been doing, in my view, unlawfully, hijacking this case, rushing it through in breach of his powers. And I think this case should be abandoned on those grounds alone, notwithstanding the legal arguments of the legal issues, where he's been biased against the Mr. Harris, who is appearing for Brian Hall and Barbara Tucker, until I think she fired him yesterday. So he's only appearing for Brian Hall, and who was told that if applications were made to him, those people would be allowed in. Now, I made an application to him, sat in the court, was told by him I'd better sit outside until the application has been made. It duly was and was refused. And then other conditions were given. He said you can make a second application when Mr. Hoare is here, because Mr. Bex is a friend of Mr. Hoare. I then put in a note, because I'd not heard any more at 2 o'clock, 2:30, asking him to make an immediate application, because I should be in that court taking my notes. I got a note back saying I can't do that. The judge has ruled that no more applications can be made until the evidence is finished. Well, this defeats the whole object of having the evidence observed in court by a member of the public, which I am.
This is a man who's attempting to have the jurisdiction of a judge and not a king in his own little kingdom, making things up as he goes along.
Exactly.
Okay, so there does seem to be some question as to his validity, really, in terms of being able to conduct this hearing in an applied due process of law and take consideration here. Also, I mean, you have made copious notes here. This term application, of course, as we know, application means you're begging, and it's presumed you know what you're giving up in order to get what you're begging for. So when you fill out an application, you are in fact consenting to whoever it is the application is made out for. So unwittingly, you've given him jurisdiction.
I may stop you there. I haven't given him jurisdiction, right, because I'm applying to another.
Oh, another court.
Another court.
I see.
So they will judge whether my application is valid and should go ahead, and they will grant the permission for it.
Did he not rule that there would be no applications after a certain date?
No, I think he meant applications for submissions to his hearing.
I'm confused. Did you make an application to the barrister that was dealing with Brian Hall?
I only made an application for permission to get it back into the court.
Right, so you made an application
which was refused.
Yeah, to get back so I could continue my observation as an observer.
And that was refused?
And that was refused, and then prevented by the judge changing his rules again and saying a second application could be heard, and it wasn't. It was refused. It wasn't even heard. So you see, he's changing the rules as he goes along. He's sitting as a dictator in his court. He is an ex-army man And far more importantly, he's just released, or not released, but just charged, judged against a paedophile who attacked a girl of 3, allegedly raping her and taking her on a terrifying car ride. And he's merely given him 5 years, this guy. And Charity Sweet, who is one of the other defendants appearing in her own right, released all this information in the court, giving out about 50 of these leaflets, which expose this judge for what he is, a criminal judge, giving lenient sentences to paedophiles, interfering in a planning matter. So who has directed him as the judge to this case? He is totally unsuited to this case and has been behaving like a rubber stamp job, behaving to get a rubber stamp job, rushing it through in...
This may seem an insignificant point, but we see that... What's his name again, this judge?
He's called Griffith Williams, and he is Sir Griffith Williams, I think David
Sir
Griffith.
Clearly you see in this photograph here, he is dressed in a judge's attire.
Exactly.
Did he dress that way today?
No, the whole point is that he's been a criminal judge dressed in mufti, in ordinary clothes as you and I are wearing, and earlier on in the trial, the claimant said, "My lord, we would like an instruction on dress. As you are not wearing dress and we are, do we take our dress off or do you put yours on?" And he ordered that they could take their dress off. So it's all a cover-up to conceal the fact that he is a bully in the form of an army kind of bully of direction, and not a man who should be handling a matter of planning law which is of crucial importance, in my view, to the hope of any chink of democracy in this country, which at the moment the Parliament Square protesters provide the codpiece concealing the immodesty of the oligarchy, which is in fact how the world is run.
Thank you very much, Colin. All right, so we're
done. Okay.
Thank you, Colin. Peace, over to you again. Because of the events that happened yesterday, I understand you've done some research and you've come up with some evidence there that was handed to you today in court. Would you care to give us some of that?
Yeah, I mean, what I have here is the police oath, judge's oath, judge's second oath, but the vital piece is supposedly they can all be put on their oaths by saying, "I'm putting you on your oath under God, so help me God." I'm not sure about this one, but now we have a contract. I don't know if that's absolutely necessary, but so that looks good, because earlier today we went to Charing Cross Police Station to try and get a constable to accompany us into court to witness that the judge was operating ultra-virus, and that was to little avail. So, I mean, there are some friendly constables around. We may be able to get one in future, but we can always try this, actually putting them on their oaths. And I mean, in hindsight, I should have ad-libbed and challenged him a bit more and said, look here, you're dishonouring the Queen. You have a duty to operate on your oath to Her Majesty Queen. I can say, in the Queen's name, honour your oath, sir. I think we need to be more, because as I was totally respectful, there was no issue of me being removed from the court or contempt of court or anything like that. So just remain calm, respectful. You put "sir" in front of things, but just once you get in there with your unalienable rights, you're on a level playing field. You can be quite sort of assertive. You have a right to be heard. You have a right to know what's going on, and don't let him bamboozle you or fob you off.
Thank you, Peace.
Okay, thank you. Thank you all.
Thank you, Colin. Thank you, Peace. And from me, Alan, at the Temple Bar in London. Wish you a very good evening.